Hi, everybody. Bill Prince here. Welcome to Chapter 2 of our discussion in Legal Environment of Business. And in this discussion, we're going to spend just a few minutes talking about the court system. And that is the contents of Chapter 2. We have to first understand what exactly is the power of the courts when it comes to our system of government. And if you recall, our founding fathers, when they created this country, were concerned about too much power being centralized in any one particular person or one particular branch of government. So they designed our government in such a way that they separated the powers and then gave each of those branches of government checks and balances on the other. So if you remember, the legislative branch, which includes Congress, they make the laws. The executive branch, which includes the president, enforces the laws, and then the court's job is to review and interpret those laws. And the famous case of Marbury versus Madison, which was decided very early on in our court's history, created this concept of judicial review, and that's the power of the judicial branch to determine if the actions of the other branches of government are constitutional or not. When we start talking about the court system and its relationship with business and its involvement in resolving disputes between businesses or between the states and businesses or between individuals or businesses, the first thing that we have to determine is whether or not the court has jurisdiction or the power to hear that particular dispute. So for courts to be able to lawfully hear a case, that court must have jurisdiction over the parties, it must have jurisdiction over the subject matter of the dispute, and the dispute must be filed in the proper court. All three of those factors must be present for the court to have the power to hear the case. Think of it this way. If you have two residents of Colorado who are fighting over property, real estate that might be in a mountain town someplace, what court would be the most appropriate place to hear that dispute? Would it be a court in New York? Would it be a court in Missouri? Would it be a court in Colorado? And obviously it would be a court in Colorado because presumably that's where the parties are, that's where the subject matter is, and that's where the right court would be to hear the case. So there has to be jurisdiction. And again, jurisdiction comes in two flavors. There's what's known as personal jurisdiction. The court must have the ability to make decisions that impact the people. It must have the power to enter lawful and binding judgments against the parties that are involved in that litigation. So as noted here, courts in Missouri would have the power to hear cases involving Missouri residents, Missouri corporations, and businesses that do business within the state of Missouri. Let's say, for example, that I live in Kansas and that I am sued by somebody in the state of Missouri in Missouri courts. I've never set foot in the state of Missouri. I've never done business in the state of Missouri. I don't have any relationship with the state of Missouri at all, yet this individual is suing me in the state of Missouri. More likely than not, Missouri would lack personal jurisdiction over me to enter any sort of judgments against myself or my property because I have no contacts with the state of Missouri. On the other hand, if I operate a corporation and my corporation does business in the state of Missouri, even though my corporation may be incorporated in the state of Colorado or Delaware, because of the contacts that I have with the state of Missouri, those courts would be able to enter binding judgments against my corporation. So the courts have to have power over the person or the entity. What about somebody who lives out of state but has contacts in some way with Missouri? Well, that gets a little trickier. Clearly, if you have two Missouri residents, Missouri courts would have jurisdiction to hear those cases. But of course, we know that we live in a world where there are transactions that are done nationally, between states, globally. When we get online and start doing transactions with Amazon or other places, Lord only knows where we're doing business with those people at. And so most states have come up with what are called long-arm jurisdiction statutes. And under long-arm jurisdiction statute, the home courts have the ability to exercise jurisdiction over a person or company that has minimum contacts within the state. And again, if you look at case 2.2 on page 29, that is a good example of a discussion about minimum contacts. So again, if I'm a business that's incorporated in the state of Illinois, and my main office is in the state of Illinois, yet I come into and solicit business in Missouri, under long-arm jurisdiction, Missouri courts would be able to bring me into those courts and make valid judgments against me. So as noted, a business can generally be sued in any state where it's incorporated, where it has its primary place of business, or in the states where it is doing business. When we talk about personal jurisdiction, we also talk about a thing called in rem jurisdiction. And really this is, in rem jurisdiction is probably going beyond the scope of what you all need to know, but this is kind of a weird kind of jurisdiction. So as noted here, if I own property in California, say for example, my parents owned land in California, and say they passed away and left me that land, but I've never been to California, never done business in California, never had any contact with California. But somebody sues me over that land, over the thing that's sitting in California, then California courts could assume jurisdiction over me personally, a Missouri resident, on the basis of my ownership of the property. But the litigation could only involve that particular property. So if there was some dispute that somebody came onto the land and was hurt and sued me as the landowner, even though I live in Missouri, I might well be brought into California, even though I've never been there. On the other hand, the fact that I own property in California, that does not give all the California courts the jurisdiction to sue me over anything. It has to deal with that land. We also have to have what's called subject matter jurisdiction. So in addition to the court having the power to make judgments over the people, the court has to have the power to hear cases involving the thing that the case is about. Some courts are what are called courts of general jurisdiction, and these courts have the ability to hear a wide variety of cases. We have in Missouri what are called circuit courts, and circuit courts have broad power to hear cases ranging from business disputes, medical malpractice, product liability, criminal cases, things of that nature. Those courts would all have proper subject matter jurisdiction because they are courts of general jurisdiction. There are also what are called courts of limited jurisdiction. Now, this jurisdiction is limited primarily through statutes or the law that creates these courts. And these kinds of cases, or these types of courts, include such things as bankruptcy courts, probate courts, family courts, and juvenile courts. And the difference between a court of limited jurisdiction and a court of general jurisdiction is that in courts of limited jurisdiction, the court can only hear the matters that the statute allows it to hear. So, for example, a juvenile court, which in Missouri is authorized to hear cases involving child abuse and neglect and criminal conduct of children under the age of 17, that court would not have the ability to hear a criminal case involving an adult. It would not have the ability to hear a contract dispute between two companies. And the reason for that is because it's a court of limited jurisdiction and statutorily prohibited from doing the same. When we talk about jurisdiction, we also talk about, in addition to subject matter and personal, we also talk about original jurisdiction and appellate jurisdiction. A court of original jurisdiction, the easiest way to think about what one of those is that's the court that has the authority to hear a case in the first instance. So, for example, if you're driving down the street and a car driven by somebody else is operated in a negligent manner and crashes into you and injures you, and you sue that person in a circuit court, a court of general jurisdiction, that would be the court of original jurisdiction. That would be the court that determines what happened, and it determines what happened through the use of competent and credible evidence in the form of witnesses and documents like medical bills and things of that nature. A court of appellate jurisdiction, on the other hand, has the ability to review a decision of a prior court in the same case. So if in your personal injury suit against the car that crashed into you, you lost, say for example, at the trial court level, you would have the ability to have that decision of the lower court reviewed by an appellate court, such as the Missouri Court of Appeals or the Missouri Supreme Court. Those are courts of appellate jurisdiction. We also have to distinguish between the state and the federal court system and the jurisdiction that each of those have. In this country, we are a federal system or a federalist system where the Constitution has set up a system where the federal government and the state government share power. And in some cases, the states have the ability to have concurrent jurisdiction or concurrent powers with the federal government. So states are allowed to set up court systems just like the federal government is. So we have state courts and federal courts. Generally speaking, state courts are allowed to hear those cases involving state statutes, those statutes made with within the four corners of the state, incidents occurring within the state, car crashes, crimes, that sort of thing, and state constitutional issues involving the constitution of that particular state. Federal courts, on the other hand, have the power to hear cases involving federal questions, which are defined as those cases involving violation of federal laws or any kind of federal law, treaties that the U.S. may have made with other countries, and issues arising under the U.S. Constitution. That's what's known as federal question jurisdiction. Federal courts also have the ability to hear what are called diversity of jurisdiction cases or diversity of citizenship cases. And in those situations, you have the litigants or the parties who have residence in one or more states, and the amount in dispute is $75,000. So let's go back to that example where somebody was driving down the street and crashed into you, and you sued them. If you were both Missouri residents, the proper place to hear that case would be the state of Missouri, because that's where both of you live. Let's say that the driver of the car that hit you was actually a resident of the state of Minnesota, and that your injuries and damages exceeded $75,000. If you sued that individual in a Missouri court because of the fact that you have diversity jurisdiction, that individual would be able to attempt to have the case removed from Missouri court and placed into federal court. And the reason for that is that basically it takes away the, quote, home field advantage, close quote, that somebody from the local state might have. So again, federal courts can hear cases involving diversity where you have residents of different states involved in a dispute, so long as that dispute, the amount involved is greater than $75,000. One thing that we'll talk about, and one thing that we will sort of see as a theme throughout this class, is this idea that the law often has trouble keeping up with technology, and as technology changes, the law often does a poor job in trying to keep up with all these advances that we are seeing, and that's occurred as well in issues involving jurisdiction. So we need to spend just a minute talking about jurisdiction in cyberspace. More and more business transactions are being mediated not in face-to-face brick-and-mortar situations, but in virtual situations where the parties to the transaction may be scattered across the country or across the globe. So what courts have done to try to deal with some of these issues involving cyberspace jurisdiction issues is that we've taken that minimum contacts analysis that we talked about in personal jurisdiction. In other words, does the person I'm suing in a Missouri court, have they had sufficient contacts in Missouri to make it fair that I sue them here? And so they've taken that minimum contact analysis and they've created a sliding scale to determine if jurisdiction in a particular state is proper or not. And these are the three things they look at. A defendant who conducts a substantial business over the internet, Amazon.com, say for example, eBay, something like that, is generally subject to the jurisdiction of the court where the plaintiff resides. A defendant who has an interactive website that allows or requires the plaintiff to take action may subject themselves to the jurisdiction of the court where the plaintiff resides. A defendant whose only presence in the plaintiff's state is through passive advertising. So, for example, I'm cruising around the web. I have a beard, if you haven't been able to tell, and I'm cruising around the web, and I come across, an article or a web thing that says, Fred's beard oil, the best in the world, available only in the state of Colorado, and so I do some research and find out how I can contact Fred's beard oil company, and I contact them by the phone, and they say, yeah, give me your credit card and we'll send you some beard oil, and they mail that beard oil to me, and I put it on my face, and lo and behold, my beard falls off. The question is where would I be able to sue Fred's beard oil at? And because of the fact that their only presence online was through sort of this passive website that didn't allow me to order anything on it and that kind of thing, it was just informational, I may well have to go to the state of Colorado to sue them there. So there's no real clear lines in any of these situations. It's always sort of a case-by-case basis that we have to look at. In addition to jurisdiction, subject matter, and personal, we also have to have venue. And venue is the court seems to have subject matter jurisdiction over an issue. The court seems to have personal jurisdiction over the parties. Have we filed this in the right place? In Missouri, we have 46 judicial circuits. So if I have a car crash in the state in the state of Missouri in Greene County, would I be able to file that lawsuit in St. Louis County or Jackson County, Kansas City, or Howell County, West Plains? And the answer to that would generally be no. I need to file the suit within the jurisdiction, the county, if you will, where that action took place. So no, I don't have the ability just to file it anywhere in the state that I want to. Now, you'll oftentimes read about change of venue, and so, for example, if a murder is committed in Kansas City and there's so much press on it that there's concerns that the defendant won't get a fair trial because too many people locally have heard about the case, there is a possibility that you can take that trial and move it to another location in Missouri where the pretrial publicity might not have been quite as great. In addition to jurisdiction and venue, parties must have standing to sue. Now, what that means is that they actually have to have been injured or aggrieved. Courts are first and foremost not just going to hear hypothetical or theoretical issues. They're only going to hear real disputes. So, I would not be able just to, I wonder what would happen if I, sued my neighbor to, find out, this or that or the other thing. Unless my neighbor's done something and has aggrieved me and broken the law or in some way or another and damaged me, I don't have the ability to drag them into court. Say for example that my neighbors across the street get into a physical altercation with each other, and one person pops the other one. Do I have the ability to sue the aggressor in that because he injured my psyche by forcing me to watch that? Probably not. So again, to go to court, you actually have to be an aggrieved party in some way or another. All right. We talked a little bit about federal court jurisdiction versus state court jurisdiction. This kind of just shows you how courts are laid out in the federal and state court system. And in both of those systems, we have what are called sort of trifold courts, I guess I would say. There's three levels of courts in each system. So let's start with the federal system first. We have what are called district courts or trial courts. Those are courts of fact. District courts or trial courts, their job is to decide what happened. They are the courts of original jurisdiction. And again, those are traditionally the courts you think of when you watch TV court shows. Judges, juries, witnesses, that type of thing. Those judges or those fact finders have to determine what happened, and then they have to apply the law to the facts. If there is a concern that the trial court erred in some way, let in bad evidence, applied the law incorrectly or something like that, everybody has an immediate right to appeal. Anybody can appeal the decision of the lower court to a court of appeals in the federal system. Once you get past the federal court, though, of appeals, it gets a little trickier. So if you lose at the federal court level, then you have a right to file a request to appeal with the Supreme Court. But the Supreme Court of the United States is extremely selective in terms of the cases that it hears. They are not required to hear all cases that are brought before it. So, usually each year there are thousands of cases that are requested in the Supreme Court to hear them, and the Supreme Court may well only hear between 75 to 100 of those tens of thousands of cases. So, think of Roe versus Wade, Loving versus Virginia, Miranda versus Arizona. The cases that come out of the Supreme Court are generally noteworthy and have significant impact on all of us. The state court system, which hears state issues, is again similar. You have circuit courts, and those are the trial courts that decide questions of fact, what has happened. If a party is aggrieved at that level, they have a right to go to a court of appeals, which are called courts of law, where they decide legal issues. Did the trial court make the right decision? And then, like the U.S. Supreme Court, the parties have a right to ask the Supreme Court to hear their cases. But again, the Supreme Court only selects those cases which, generally have, broad application to the majority of us, or have, certain legal issues that need to be decided. All right, well, that's a quick rundown, maybe not as quick as the last one, of the court system. Again, any questions, do not hesitate to contact me, and we'll visit with you again in our next lecture. Take care.